Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here.
Imagine you've poured years into research, painstakingly developing, a life-changing medicine, and then securing that vital patent to protect your innovation. You've built a brand, launched products, seen global success, only to discover a competitor, not just selling something strikingly similar, but even like brazenly copying your website content to market it. What do you even do then?
It's a nightmare scenario for any innovator, truly.
Welcome to the Deep Dive. Our mission today is to unpack a really fascinating recent judgment from India. It's a case that shines a bright light on how courts actively protect intellectual property in the rapid-fire, high-stakes world of pharmaceutical innovation. We're going to take your sources, this incredibly detailed court judgment, and really extract the most important nuggets of knowledge, giving you a shortcut to being well-informed and understanding the real-world impact of these decisions.
Absolutely. We're diving deep into the specifics.
Today, we're diving into a high-stakes battle involving patent infringement for a crucial anemia treatment. But as we hinted, there's also this surprising twist, website copyright infringement thrown into the mix. We'll explore the original claims, the defendant's counterarguments, which took an interesting turn, and the court's powerful reasoning that led to a significant interim injunction. It's a complex case, yeah, but with clear implications for anyone in the innovation space, from startups to, established giants.
Definitely a lot to unpack here.
Okay, let's dig in. To kick us off, can you give us the essential groundwork? Who are the main players in this legal drama? Which court made this ruling? And when did this all unfold?
Absolutely. So this judgment comes from the High Court of Delhi at New Delhi. The decision itself was rendered on August 29th, 2025. The case was heard and the matter overseen by the Honorable Mrs. Justice Manmeet Pritam Singh Arora.
Okay, single judge.
Yeah.
And the parties involved.
Right. On one side, we have the plaintiffs, Frimline Private Limited and A&R. So Frimline Private Limited is plaintiff number 1, the main innovator, and its parent company is plaintiff number 2. And standing against them are the defendants. K-Smatco Lifesciences Private Limited and ORS. K-Smatco Lifesciences is defendant number 1, and then defendants 2, 3, and 4 are individuals closely associated with K-Smatco.
Got it. And their legal teams. Big guns involved.
Seems like it. Representing the plaintiffs was a team led by Mr. Dayan Krishnan, senior advocate. For defendant numbers 1, 3, and 4, Mr. Santosh Kumar, advocate, appeared. But, and this is quite notable, host speaker, defendant number 2 chose not to provide instructions to counsel.
Oh, interesting. Just didn't show up, essentially.
Well, unrepresented, which, as we'll see, became pretty significant later on.
Okay, so we have our cast and our setting. What's the core story here? What was this innovative product, and what chain of events led to this legal showdown?
Right, at the very heart of this deep dive is Indian patent number 382949. It's titled A Pharmaceutical Composition for Anemia. This patent was filed by Frimline Private Limited back in early 2018, March 9th to be exact, and it was officially granted on November 29th, 2021. It's got protection extending all the way to March 38.
So a fairly recent active patent, what does it cover exactly?
It protects a pharmaceutical composition specifically designed to treat, several things. Iron deficiency anemia, IDA, anemia of inflammation, AOI, and even certain neurodegenerative disorders. Now, what's really innovative here is its unique blend. It claims a synergistic combination of lactoferrin LF and one or more guanosine nucleotide or its pharmaceutically acceptable salt.
Synergistic, meaning they work better together than apart.
Exactly. It's not just mixing ingredients. It means these components work together to create a greater effect than if they were used separately. This particular formulation uses natural ingredients, aiming to reduce common side effects and maintain the body's iron balance more effectively. Iron homeostasis.
That does sound like a genuinely significant step forward, especially for something as common as anemia. And Frimline didn't just patent this, they actually sold products based on it, right?
Precisely. They didn't let this patent just sit on a shelf. The plaintiffs launched their first product, Ferrinomic, back in June 2018, even before the patent was granted, interestingly. Then followed others like Ferranemia Plus. These products, leveraging they argued was their patented composition, generated some pretty impressive global revenue, around Rs 331 crores since 2018.
Wow, 331 crores. So serious money involved.
Absolutely. And they also secured trademark registrations for their brand names, showing a significant investment in both the R&D and building their market presence.
Okay, so that sets the stage for the conflict. How did they find out about K-Smatco's product? What was the trigger?
Well, the plot really thickened on July 16th, 2025. That's when the plaintiff's representatives discovered a product called Ferritalk Plus from the defendants popping up in the market. A quick look at the packaging revealed its ingredients: lactoferrin 50 milligrams, disodium guanosine 5 monophosphate 5 milligrams, and elemental iron. This immediately raised red flags because it looked very, very similar to their patented synergistic composition.
So they saw the ingredients and thought, hang on a minute.
Exactly. They quickly followed up with a detailed analysis, a certificate of analysis, to confirm their suspicions about the composition matching their patent claims. But it wasn't just the product itself. They made another discovery, which was, frankly, quite astonishing.
A website thing.
Yeah, defendant number 1 had blatantly copied information from plaintiff number 2's website. We're talking literally lifting content history, divisions, events, using it as their own. This website content is protected under copyright law as literary work. The plaintiffs argued this was a clear attempt to mislead the public, trade off their established reputation.
Wow.
It is. And adding another layer of concern, defendant knows 3 and 4, who are now in senior management roles at defendant number 1, K-Smatco, were actually ex-employees of plaintiff number 2, the parent company.
Oh, the plot thickens indeed. Ex-employees involved.
Right. So you have potential patent infringement, blatant website copying, and former employees now at the competitor. It paints quite a picture.
So it wasn't just a potential patent issue, but like a full-blown intellectual property assault, hitting patents and copyrights, even their digital presence. That's a huge concern, especially in pharma, where trust and accuracy are everything. What were the immediate legal questions the court had to grapple with here for this initial injunction?
Precisely. The stakes were very high. Think about it. These anemia treatments are often used by vulnerable people, like pregnant women. The plaintiffs were deeply concerned about potentially substandard products causing harm. So the court's immediate task in this application for an interim injunction was to determine 2 key things. First, was there a prima facie case? Meaning, did Frimline present enough initial evidence to show, on the face of it, a strong likelihood that K-Smatco was infringing on both the patent and the copyright?
Okay, step 1. Does it look like infringement is happening?
Right. And second, if yes, was an immediate injunction necessary to prevent further harm? Harm both to the plaintiff's business, lost sales, reputation, and, crucially, potential harm to the public.
Makes sense. So Frimline comes to court armed with their patent, their big sales figures, the copied website.
Yeah.
What was their main legal strategy? How did they argue their case?
They came in strong, hitting both the patent and copyright angles hard. First, they firmly established that their patent, EN 382949, was valid, subsisting, granted back in 2021. To prove the patent infringement, they presented a detailed claim mapping analysis. This is really where the technical details come in.
Claim mapping, like lining things up side by side.
Essentially, yes. They meticulously compared their patent claims, which are the legally defined boundaries of their invention, against the specific ingredients listed for the defendant's Ferritalk Plus's product. They showed, ingredient by ingredient, how it matched up. And they backed this up with that certified analysis of the actual infringing product they'd obtained.
Okay, so direct comparison. What else?
A critical giggle point they really zeroed in on was the word comprising in their main patent claim, Claim 1. This isn't just semantics. In patent law, comprising is a very important term. They argued it grants broader protection. It means the patent isn't limited to only the exact elements listed, but also includes compositions that have those elements, plus potentially other things. It's an inclusive term.
So comprising means including at least these things, not consisting only of these things.
Exactly. That was key. It allowed them to argue that even though the defendants used disodium guanosine 5 monophosphate, which is technically a salt of guanosine monophosphate, it still fell within their patented scope because guanosine monophosphate was listed in the claim using comprising. To hammer this home, they pointed to their complete patent specification, the full document. They highlighted the detailed description of the invention section and a specific example, example 22, which explicitly mentioned and enabled the use of disodium guanosine monophosphate.
So they showed it wasn't just in the claims, but explained in the details, too.
Right. They connected the claim language back to the detailed description, reinforcing that their invention, as fully described, inherently covered the specific ingredient found in the defendant's product. It wasn't some minor loophole. For the website, well, that was more straightforward. They argued Defendant number one's wholesale copying was undeniable copyright infringement, clearly designed to mislead people and piggyback on their reputation. And they brought up the money again, the 331 crores.
They did. They highlighted their significant commercial success as evidence of their invention's value and public acceptance. They also mentioned they'd successfully overcome initial objections from the Indian Patent Office during the patent application process, basically saying, look, this patent was thoroughly examined and found to be novel and inventive. Ultimately, their argument was clear. The defendants' actions were causing substantial financial and reputational damage, and an injunction was absolutely necessary to stop the bleeding, especially given the public health aspect.
Okay, that sounds like a very robust case from Frimline. But, there are always two sides. What did K-Smatco, Lifesciences, and the other defendants say? How did they try to defend themselves?
Well, the defendants specifically, defendant knows 1, 3, and 4, because remember, defendant number 2 was silent. They did try to raise some points. They attempted to cast doubt on the patent's validity itself. They pointed back to that initial first examination report, FER, from the Patent Office, which had initially raised concerns about novelty and inventive step. They sort of suggested maybe this patent isn't as strong as they claim.
Trying to undermine the foundation.
Exactly. They even questioned the authenticity of the as-granted claims Frimline presented, asking for a certified copy, which seems like a bit of a delaying tactic, maybe. They also threw out the argument that the composition itself was just a commonly available formula. They claimed there were approximately 30 to 40 different products with a similar chemical composition already out there.
So trying to say it wasn't really inventive?
Yeah, pretty much. Undermining the novelty and inventive step. They also quibbled a bit over the technical details of Frimline's analysis of their product, the lactophanerin percentage, saying it wasn't admitted. Minor point, really. But crucially, host speaker. Defendant number 1, K-Smatco, tried to distance themselves by claiming they were just the distributor. They said they couldn't provide details on the product's composition because that information was solely with defendant number 2, the manufacturer.
Ah, passing the buck to the missing defendant number 2.
Precisely. That information gap, combined with defendant number 2's silence, really left a big hole in their defense strategy. It didn't look good.
Yeah, that does sound like a weak defense, kind of throwing up smoke. But I understand there was a pivotal moment, a really significant shift in their position later on. Tell us about that.
Yes, absolutely. This is where the case took a dramatic turn, really shifting the dynamic. In their later written submissions, the defendants made a declaration that basically changed everything. Defendant number 1 stated they had voluntarily withdrawn manufacturing order issued for the product Ferritalk Plus and stopped marketing selling the same right after they were served with the lawsuit papers.
Wow, they just stopped voluntarily.
That's what they claimed, a huge admission, effectively. And it didn't stop there. They also committed to not launching any infringing product again. And regarding the website, they sincerely regretted what they called the mistake of their officials in the inaccurate website description. They stated they had already withdrawn that content and promised to update it.
So basically admitting fault on both counts, or at least stopping the activity.
It certainly reads that way. It's essentially a cessation of all the alleged infringing activities. Whether truly voluntary or a strategic retreat in the face of strong evidence, it made the court's decision on the interim injunction much, much clearer. It's a classic move, sometimes cut your losses when you're caught red-handed.
Okay, so with Frimline's strong case, the defendant's weak initial defense, and then this dramatic voluntary withdrawal, how did Justice Arora ultimately rule? And what was the core reasoning behind that decision?
Well, given all that, the court's decision was pretty clear and decisive. An interim injunction was granted fully in favor of the plaintiffs, Frimline. The judge was strongly persuaded by Frimline's argument about how to interpret the term comprising in Claim 1 of the patent. She relied on established legal precedents, like the Hoffman-LaRoche v. Cipla case, and authoritative texts like Terrell on patents.
So confirming that comprising is broad.
Exactly. The court reaffirmed that comprising is an enabling and not restrictive term. This is so crucial for innovators because it means the patent isn't limited only to the listed elements. It allows for minor variations or additional components without losing protection. It stops competitors from making tiny, non-inventive tweaks just to try and get around the patent.
Right, protects the essence of the invention.
Precisely. The court also stressed that fundamental principle. Patent claims must always be read in conjunction with the complete patent specification. You don't just look at the claim in isolation. You have to understand it in the context of the whole document, the detailed descriptions, the examples. And in this case, the detailed description, and specifically that example 22, explicitly included disodium guanosine 5-monophosphate. This detail confirmed that the defendant's product, using that specific salt, fell squarely within the patent's protected scope. It wasn't ambiguous.
Okay, so reading the whole document was key to seeing the infringement.
Absolutely. By doing that claim mapping and pointing to the specification, Frimline had clearly established a strong prima facie case of patent infringement. The defendants, notably, offered no real explanation for their formula's origin and didn't effectively challenge Frimline's analysis. And as we mentioned, defendant number two's absence just further weakened their position and basically substantiated Frimline's claims by default.
And what about the website copying?
On that front, the defendant's own statement they're undertaking to withdraw and correct the infringing content was taken on record by the court. This effectively confirmed that copyright infringement had occurred. They basically admitted it by promising to fix it. So the court issued a comprehensive interim injunction. It restrained all the defendants 1, 2, 3, and 4 from making, selling, advertising, or doing anything else with any product that infringed Indian patent number 382949.
And this injunction lasts.
It's confirmed until the final disposal of the main lawsuit for defendants 1, 3, and 4. For defendant number 2, because they weren't represented, it's until the next hearing date, giving them a chance to appear. A similar interim injunction was also granted for the copyright infringement. It was a very strong, clear win for Frimline at this stage.
Makes sense. Now, to arrive at such a detailed decision, courts always lean on existing laws and past cases, right? What were the key statutes and precedents that Justice Arora relied on here? Was there any disagreement, like a dissenting opinion?
Right. The ruling wasn't made in a vacuum. It drew on a solid mix of Indian statutory law and established judicial precedents. The injunction application itself fell under the Code of Civil Procedure, 1908 standard stuff for civil cases. The core patent issues involved the Patents Act, 1970, particularly Section 10(4)(c), which talks about how claims define the invention's scope. For the website, it was the Copyright Act, 1957, specifically Section 13(1)(a), defining literary work. And importantly, Frimline also showed they complied with Section 83 of the Patents Act, which deals with demonstrating the commercial working of the invention, showing it's not just a paper patent.
Okay, so the specific laws were applied. What about previous court decisions?
Yes, precedents were crucial. For interpreting patent claims and analyzing infringement generally, the court cited cases like Gwala Closures, SPA v. AGI Greenpack Limited, and Mold Tech Packaging Ltd v. Pronton Plastpack, PLTD. That key interpretation of comprising was heavily guided by a major division bench decision in F. Hoffman LaRoche Ltd. and NR v. Cipla Ltd., and also the highly respected text Terrell on the Law of Patents, and the principle of reading claims together with the entire specification. That was reinforced by a Supreme Court decision, Biswanath Prasad Radhesham v. Hindustan Metal Industries. So a strong foundation of case law.
And any dissenting opinions? Different views from other judges?
No, none at all. This was a clear-cut judgment from a single judge, Justice Arora. It showed a consistent application of these established legal principles to the specific facts presented by Frimline. No internal disagreement recorded.
Got it. So, stepping back, what does all of this mean for you, our listener, and for the broader legal landscape, especially in pharmaceuticals? What's the lasting impact or, the presidential value of this ruling?
Well, I think this deep dive offers several really important insights for anyone involved in IP. First, it powerfully reaffirms this idea of dynamic claim interpretation. What that means for you if you're an innovator is that your patent claims, especially if they use inclusive words like comprising, won't be read super narrowly or just literally. Courts will look at your entire patent document, the detailed description, the examples to understand the real scope and spirit of your invention.
So it protects against those minor tweaks competitors might try.
Exactly. It's a strong shield against someone making small, non-inventive changes just to try and design around the claim language. It protects the substance. Second, the case really highlights the burden of explanation on defendants. If you're accused of infringement, just saying, oh, it's a common formula or someone else has the details likely won't cut it, especially if the plaintiff has solid evidence. You need to be able to show the legitimate origin in your product.
Right. You can't just deflect.
No. Third, it demonstrates the court's willingness to provide swift protection for IP owners through interim injunctions. When you have strong evidence of both patent and copyright infringement, and especially when things like public safety or clear unfair competition are involved, the courts can act quickly to stop the harm. And, the defendant's voluntary stop certainly didn't hurt. Frimline's case, it showed the court the strength of their claims was recognized.
And finally,
it underscores a holistic approach to IP. It's not just about the patent in isolation. It's about the copyright in your website, the trademarks for your brands. All these intellectual assets work together to build your company's value and identity, and the legal system can protect them comprehensively.
What an incredibly insightful deep dive. Honestly, from specific chemical compositions for treating anemia all the way to, well, website content, this case really covers the breadth and critical importance of intellectual property law in protecting innovation and ensuring fair play.
It truly does. And if there's one single most important key takeaway from this judgment for everyone listening, I'd say it's this. When interpreting patent claims, especially those using broad terms like comprising, courts will look beyond the literal claim wording. They will dig into the complete specification descriptions, examples, the whole 9 yards to grasp and protect the true scope and spirit of the invention. It's this comprehensive approach that really safeguards innovation.
That's a great summary. Now, this case involved an interim injunction, right, which is a temporary measure.
Yeah.
It makes you wonder what further battles might Frimline and K-Smatco face as this lawsuit moves towards a final decision. There could still be appeals, damages assessments, and maybe a bigger question. How might this kind of robust enforcement of patents and copyrights, as we saw here, impact the overall pace and direction of future innovation in the pharmaceutical industry?
Oh.
Does it encourage genuine breakthroughs, or could it potentially stifle competition in some ways? Definitely something to mull over.
Interesting questions for sure. The ongoing impact is always complex.
Thank you for joining us on this deep dive into legal innovation and protection. We hope you feel a little more well-informed and perhaps even a little more curious about the complex legal world around you. We'll catch you on the next deep dive.